Hello everyone, I'm Xiaoping Hu. I'm the moderator for this webinar. Thank you for your time in joining us. As one of the leading IP firms in China, SPTL has been providing a range of IP services since 1984. Today, one of our patent attorneys, Ms. Evan Pu, will share with us an interesting topic about the third-party observations in China and also in the PCT international phase. Evan is a senior patent attorney. She has over 20 years of experience in mechanical fields. She is seasoned in drafting, prosecution, re-examination, infringement analysis, and invalidation. Today, Evan's presentation will last about 30 minutes, and then we have several minutes for question and answer. Or please raise your questions through text message during the presentation. Now, let's welcome Evan.
Thanks to our senior partner, Ms. Hu, for her introduction and warm welcome. Hello, everyone. I'm delighted to be speaking with you today. In today's webinar, I would like to share with you a practice of third-party observation for challenged patent application before grant, as well as corresponding strategies for finding the observation in China. In practice, some companies will regularly search their competitors' published application and patent to determine whether they pose a threat to their own market activities. If a relevant patent is found, the company would start an invalidation proceeding to challenge the patent right. If a relevant patent application is found, what can we do? Launching an invalidation proceeding after the application is granted. Actually, we have another approach for challenging the patent application. That is the third-party observation, which we also call it as public observation in China. Companies can consider using the third-party observation to block the granting of the competition. Consider using the third-party observation to block the granting of the competitor's patent application or to narrow the scope of protection of its claims so that the risk of infringement of company's own products may be eliminated. Today, I will share with you the information regarding the third-party observation from the four aspects. Practice of the observation regarding a Chinese patent application. Practice of the observation regarding a PCT application in its international phase. Comparison of observation between China and in Japan, US, EPO, and the PCT. Finally, we would like to share you with some strategies and tips of observation based on our practice. First, I will introduce you with some rules and practice of the third-party observation in China. First, let's see the legal basis for the public observation. Rule 48 of the Implementing Rules of Chinese Patent Law stipulates the provision of public observation, that is, from the publication date of the invention patent application to the date of the announcement of the grant of patent right. Anyone can submit an observation to the CNIPA and explain the reasons why the patent application does not comply with the provisions of the patent law. Meanwhile, the patent examination guidelines stipulates that the public observation should be put into the patent file wrapper for consideration by the examiner during the substantive examination. If the public observation is received after the notification to grant the patent right is issued, it does not need to be considered. the CNIPA does not need to notify the third party of their handling of the observation. According to the above regulations, we know any individual, enterprise, or institution, even including the applicant himself, is entitled to submit the observation anonymously. The timing for submitting a third-party observation is from the publication date of the invention patent to the date of the notification of grant of the patent right. For patent application entered into China under Paris Convention, the application will be published after 18 months from the priority date. That means the observation for the application under Paris Convention can be filed after 18 months from the priority date. Since the Chinese examiner will be more likely to consider the observation before he issues a first-off sanction, it's recommended that the observation to be submitted as soon as possible upon we know a related application is published. What can we submit in the third-party observation in China? In China, the observation can involve various grounds for rejecting the application. That is, the observation can include any evidence and reasons that prevent the applicant from being granted or narrows the scope of protection of the claims. By the way, the observation in China can be only submitted to challenge invention patent application. Utility model application cannot be challenged. We can submit the reference documents with detailed explanations, or we can only submit some formal defects in the observation. Of course, it's recommended to submit evidence together with reasons for undermining novelty and inventiveness. Another question is, how many times observations can be submitted to the CNIPA for one case? The answer is there is no limitation to the number of submissions of observation in China. The same submitter can file with multiple observations to challenge one application. Then, how the observation will be handled by the CNIPA? The guidelines stipulates that the third-party observation should be put into the patent file wrappers for consideration during the substantive examination. But if the third-party observation is received after the examiner has issued a notification to grant the patent right, the examiner will not consider the observation. Examiners will not notify the applicant of the receipt of the observation. However, through inquiries, one can see the submitting records as the intermediate documents in Chinese patent examination inquiry system, but the detailed content cannot be checked. In addition, the content of the observation cannot be retrieved or from the CNIPA, as the CNIPA set rules on the confidentiality of the observation. On the other hand, the examiner will also not tell the submitter whether he has adopted or well-adopted opinions in the observation. Someone may ask, what's the success rates that reference documents and the relevant arguments in the third-party observation are adopted by the Chinese examiner in the office action? For this, we made a survey of all the public observations that our department have handled these 5 years from the Patent Information Inquiry System. From this system, we can see the detailed remarks in the office action of these applications, and we found that above 75% of reference documents or arguments we submitted were adopted by the examiners. In addition, we have also checked those cases that reference documents cited in the observation have not adopted. Among these cases, some because the examiner cited other relevant reference documents, and the examiner may believe the documents he cited were more appropriate. In other two cases, the claims have been voluntarily revised before the officer action is issued. This slide shows the website of China Patent Examination Information Inquiry System. The left picture is a front page of the system. You may enter into the system through public inquiry. If an observation is submitted in the rights interface, you may see a record named Other Certifying Documents as the intermediate documents. From this system, if you find an unknown intermediate document, this document will probably be the third-party observation submitted by others. So from this website, you can check if your case is challenged by others. And on the other hand, you also can check if the observation you submitted is safely received by the CNIPA. So what's the benefits from the observation? The most ideal result from the observation proceeding is to suspend a patent application before the grant, so it cannot constitute a valid patent. If the ideal result of stopping grant cannot be achieved, the scope of protection of allowed patents may be limited to a certain extent, so that related products can avoid the scope of protection of patents. Anyway, the commercial interests can be pursued without fear of patent rights. Especially comparing with the invalidation proceeding, submitting third-party observation during the application prosecution period is more cost-effective and time-saving. No translation is required for reference documents in foreign language. As observation can be submitted anonymously, the submitting observation is concealed. There is no need to prepare power of attorney or identification materials. Whatever the submitted observation is considered by the examiner or not, the contents in the observation can still be used in a post-grant invalidation proceeding. We have been asked, will the third-party observation have a negative impact on the use of the same reasons and evidence in the invalidation stage? Generally speaking, the filing of observations with the CNIPA does not preclude the same arguments being put forward in post-grant proceedings. Normally, in the invalidation stage after granting, the collegial panel will make their judgments independently, rather than directly refer to the opinions in the substantive examination. If the examiner does not use the reasons or evidence in the third-party observation at all, this will not affect the consideration of same evidence and reasons in the post-grant proceeding. If the reasons and evidence are adopted by the examiner, but the patent application is still granted as the applicant made amendments or submitted arguments, in this case, the chance of this evidence and the reasons being reconsidered in the post-grant proceeding depends on whether the granting is reasonable. We have cases that the evidences in using the substantive examination stage successfully invalidated the granted patent in the post-grant proceeding. Now let's turn to the second part, how to file with an observation for a PCT application during its international stage. Since mid of 2012, it has been possible to file observations against PCT applications at its international phase. This system allows third parties to make observations through EPCT system. As same as in China, the person making the observation may indicate that they wish to remain anonymous. Third-party observation may be submitted at any time after the publication date of the international application and before the expiration of 28 months from the priority date, with the applications not withdraw or consider withdrawal. In the observation system in PCT international stage, now it's only possible to comment on novelty and inventiveness. The regulation only allows the use of maximum of 5,000 characters to describe the relevance of each cited reference document, only allowing short and brief arguments to be made. There is also a maximum of citations, which is 10. Further, one third party may only submit a single observation for any international application, and once submitted, it cannot be retracted or modified. There is also an upper limit of 10 observations per international application. Next, let's see what will happen if an observation is submitted for PCT application. The applicant will be notified about the first published observation, and all subsequent observations will be promptly notified after the expiration of 28 months from the priority date. The applicant may comment on the third-party observation until the expiration of 30 months from the priority date. The applicant's comments should be submitted in English, French, or the language of publication of the international application. The comments will be made publicly available on the website. If the International Bureau has not yet received the International Search Report, Supplementary Search Report, or Preliminary Search Report on patentability, observations will be transmitted to any competent searching authority and/or preliminary examination authority involved in the processing the application during its international phase. To the extent that the observations are received by those authorities in time to be taken into account in drawing up their reports, any prior art referred to the observation should be considered. The observation will also be transmitted to the designated offices promptly after the expiration of 30 months from the priority date. As a result, third parties can take advantage of the centralized procedure to have a single set of submissions brought to the attention of the relevant international authority and the national regional phase patent office, as well as the applicant. However, it should be noted that the designated office are not obliged to take them into account during national processing. Next, let's compare the observation rules in China, United States, European Office, Japan Patent Office, and the PCT International phase. From this slide, you can see the timetable that the observation can be filed to the different offices. In Japan, a third-party observation can be submitted at any time after a patent application or application for utility model registration is filed, even after a decision is made to grant a patent or utility model registration. In US, the third-party submissions must be filed before the later of 6 months after the publication date or the later of first of section, or before the date of notice of allowance if it's earlier. In EPO, observations could be submitted at any time after publication of a pending application, including after a patent application has received a communication for intending to grant a patent. They may also be submitted in an ongoing opposition as well as during appeal proceedings. This slide shows the contents that can be included in observations in the 5 offices. You may see that in China, there is less criteria for the submission. The observation may include various patentability grounds. On this slide, the comparisons relate to the 3 aspects: whether the applicant is informed with the observation, whether the observation can be retrieved or copied, and whether the applicant can make comments or response to the observation. You may see that only the third-party observation in China will not notify the applicant, although the applicant may find a record of relevant documents from the patent examination inquiry system. However, the applicant will not take initiative to go check the information. At the same time, only the details of third-party observation in China are kept secret. Finally, the observation system in China is the same as those in most patent offices. The applicants have no chance to make comments. Only the applicant of PCT application has the opportunity to reply to the observations within the due course. Now we come to the last part of today's webinar. We would like to provide you with some strategies and tips for filing observations in China. First, regarding the submission of public observation in China, we have some tips. We may submit some reference documents that may be overlooked by the examiner. At present, according to our practice, the Chinese Patent Office has a high standard for novelty and inventiveness. Those relevant patent documents before the filing date or a priority date normally will not be missed, but some non-patent documents, such as professional journals, professional books, may be not cited. So, if the third-party observation is submitted with these kinds of reference, which will be a significant supplement for reference cited by the examiner. It will be also appropriate to submit the prior art goes to novelty or very straightforward obviousness arguments, and the design outcome is to have the claims narrowed so as to not cover a specific product or process. In China, there is no limitation on the number of reference documents, but we don't suggest to use a complicated combination of prior art for rejecting inventiveness. If reference documents are cited to comment inventiveness, it's better that the number of documents used in combination is no more than 3. Another suggestion is, before submitting the observation, all the family applications could be reviewed, so we can know possible amendments to the application, and we can prepare a more targeted observation to cover any possible amended claims. In China, we can submit formal issues in the observation, such as unclearness, lack of support, or lack of essential features. Whether or not formal issues should be raised and which formal issues should be raised mainly depends on the desired scope of patent protection. After the submission of an observation, the follow-up office action made by the CNIPA could be checked. The office action from the CNIPA can be found from the website. If the office action does not include content the third-party observation, or the applicant has already amended the claims to evade those defects you submitted in previous observation, we may contact the examiner by phone or supplement another observation. Finally, let's take a general look at the advantages and disadvantages of submitting observation. As previously discussed, there is no estoppel that prevents a third-party submitter from using the same reference and arguments in other proceedings. That is, the same reference and arguments can be reconsidered in an invalidation procedure. Compared with the invalidation procedure, the cost of observation is much lower. There is no official fee for submitting the public observation, and the attorney fee may be only 1/5 or to 1/8 of the expenses for the patent invalidation proceedings. There is no filing fee for submitting observations in China, and the procedure is very simple. No translation of the reference documents is necessary, and observations can be submitted anonymously. On contrary, in an invalidation procedure, especially in the invalidation appeal stage in court, the requirements for evidence and agency procedures are obviously more complicated, especially for a foreign party. For example, notarization and certification of the power of attorney are necessary. Further, observation system allow to raise some reasons that cannot be raised in the invalidation. For example, the reason for unity cannot be raised in the invalidation system, but is acceptable in the observation system. But submission of observations also has some negative effects. Although it can be submitted anonymously, as there will be a record as the intermediate documents in the inquiry system, the applicants can still be alerted if they query in time. The applicant has the most flexibility to make amendments to the application documents. Even it may encourage the applicant to take some steps to strengthen the protection. For example, continue with an application that is may otherwise have allowed to lapse, filing divisional applications, and proceeding with the application in other jurisdictions. On the other hand, if a patent application is granted a patent right after the observation system is used, the applicant may end up with a stronger patent that is more difficult to attract in post-grant proceeding. This comes to the end of my webinar today. I hope the information just provided will be helpful to you or your clients to have a comprehensive patent application challenge strategy with the observation system. Thank you for your watching.
Thanks for your sharing, Evan. Now let's go to the Q&A session. Let me check. There's a question from Mr. Lucien White. The question is, as you just mentioned, it will be best to submit the TPO before the first office action is issued. And then, how long will it take to receive the first office action after the application is published?
Okay, thank you for your question. According to our practice, upon an application is published and enter the substantive examination stage, normally a first office action will be received within 6 months to 18 months. If one application requests a PPH program, that's a Patent Prosecution Highway Program, a first office action may be received within 2 or 3 months after the PPH request is accepted.
Okay, thank you, Evan. It seems there's no further questions at this moment. Anyway, if anyone has further questions, please send us your question by email. That's all for today's webinar. Our next webinar will be hosted in September, which will focus on the proposed amendment to the patent examination guidelines. So stay tuned. Thank you again for being with us. Have a good day.